This is a review of BLLE Chapter 3, Courts and the Legal Process. After having read the chapter, we should be able to describe the two different court systems in the United States and explain why some cases can be filed in either court system, explain the importance of subject matter jurisdiction and personal jurisdiction, describe the various stages of a civil action, and describe two alternatives to litigation, mediation and arbitration. Just as the branches of government are separate yet unified, so are our federal and state court systems. Law and government are interdependent. The legislative branch creates law, the executive branch enforces law, and the judicial branch interprets and applies the law. State court systems and the federal court system are also interdependent. There are two court systems, state and federal. But really there are 52 court systems if you count separately that of each state, local system, and the DC and federal circuit systems. Pursuant to the Supremacy Clause in the United States Constitution, state and local courts must honor federal law. Also pursuant to the Constitution under the Full Faith and Credit Clause, each state court is obligated to respect the final judgments of courts in other states. Article 3 of the United States Constitution establishes our federal court system, which states that the judicial power of the United States shall be vested in one Supreme Court and such lower courts as Congress may establish. The largest grouping of courts are the United States District Courts. Congress has established 94 federal judicial districts, each located entirely in a particular state. United States District Courts decide issues of fact and are the general trial courts in the federal system. California has 4 federal judicial districts. Congress also established 13 judicial circuits, each having a court known as the Court of Appeals. They hear cases from the district courts located within their circuit. They review decisions of administrative agencies, tax court, and the bankruptcy courts. They also examine the record of a case on appeal to determine whether the trial court committed some prejudicial error. The Supreme Court is our nation's highest tribunal. It is comprised of 9 justices, which includes 1 Chief Justice and 8 Associate Justices. A quorum consists of any 6 justices. The Supreme Court has some original jurisdiction, but mostly it has appellate jurisdiction via appeals by right or writs of certiorari. The Supreme Court reviews the decisions of the federal courts of appeals and also the decisions of the highest state courts involving federal law. The federal court system in the United States also has special courts, which are highlighted here in gold. They have jurisdiction over particular subject matter, which means that they have jurisdiction over cases in a particular area of federal law. As it relates to the state court system, each of the 50 states and the District of Columbia has its own independent court system. In most states, the voters elect judges for a stated term. The structure of the state court system varies from state to state, but generally speaking, there are some courts that have original jurisdiction, which means that they have the jurisdiction to determine the facts of the case and apply the law to them. That includes trial courts, inferior trial courts, and special courts. Most states also have courts of appellate jurisdiction, which means they accept the facts as determined by the trial court and limit their review to the lower court's theory of the applicable law. That would include a state Supreme Court and immediate appellate courts. In the state court system, there are courts of limited jurisdiction. These are the lowest level of courts. 80% of cases are heard in courts of limited jurisdiction, and these include small claims courts. Next, we have our courts of general jurisdiction. They hear all other civil and criminal cases that are not heard in limited jurisdiction courts. They mostly hear family law cases, personal injury cases, and commercial law cases. Next, we have our appellate courts. Intermediate appellate courts, also known as the courts of appeal, have been established in 40 states. They do not retry the evidence. However, they determine whether the trial was conducted in a procedurally correct manner and whether the appropriate law was applied. Usually, these courts are composed of a panel of 3 judges. Then we have the state Supreme Court, which is composed of a single panel of between 5 and 9 judges, and their ruling is final. Lastly, most state court systems also have special courts, which only hear a certain type of case. These could be like landlord-tenant cases or probate of will cases. The decisions here are usually final, although any party dissatisfied may be able to get a new trial in a court of general jurisdiction. In order for a party to bring suit in a court, whether it be state or federal court, they must have the capacity to sue, which we call standing. In order to invoke a court's jurisdiction or have the standing to sue, a plaintiff must at least demonstrate that 1. They suffered a distinct and palpable injury as a result of the defendant's putatively illegal conduct, 2. That the injury is fairly traceable to the challenged conduct, and 3. That the injury is likely to be redressed if the requested relief is granted. Last year, Sarah Palin sued the New York Times for defamation, but how did she know that the court in which she filed her complaint was the right court? Also, how does the court know that it can say something about the matter? These are questions of jurisdiction. Jurisdiction is the power of a court to hear and decide a given case. To have that power, a court must have, and the plaintiff must establish, that venue is proper, that the court has subject matter jurisdiction, and also that the court has personal jurisdiction. Here you can see how Sarah Palin establishes first that the court is the correct geographic location to hear her case, i.e. venue. She also establishes that the court can hear the merits of the case, thus they have subject matter jurisdiction. Also, she shows that the court can enforce a judgment against the defendant and the defendant is appropriately before the court, thus the court has personal jurisdiction. Territorial jurisdiction refers to jurisdiction over cases arising in or involving persons residing in a defined territory. Law enforcement officers, whether part of federal, state, or local government, generally have some authority to make warrantless arrests only in their own geographic territory. This authority is sometimes called territorial jurisdiction. As it relates to the judiciary, jurisdiction takes on a greater meaning. We have personal jurisdiction, subject matter jurisdiction, and something that is very similar to a territorial jurisdiction that we call venue. Subject matter jurisdiction is the authority of a court to judge a particular kind of controversy. Federal courts have the exclusive federal jurisdiction in areas of laws that Congress provides either explicitly or implicitly. State courts have jurisdiction over all other matters that Constitution or Congress neither denies them nor gives exclusively to the federal courts. When there is concurrent jurisdiction, state and federal courts can hear the same kind of case, i.e., when a federal court hears a state law matter. To have concurrent jurisdiction, there must be either federal question jurisdiction or diversity jurisdiction. Under federal question jurisdiction, the federal court has the subject matter jurisdiction to hear a case because the plaintiff has alleged a violation of the United States Constitution, federal law, or a treaty to which the United States is a party. Under diversity jurisdiction, the federal court has the subject matter jurisdiction to hear a state law matter because there is complete diversity of citizenship and the amount in controversy exceeds $75,000. So let's do an example. Danny is driving on a road in Riverside when he unintentionally strikes a cyclist, Peter. Peter incurs extensive personal injuries in the amount of $50,000. Danny and Peter are from California. This type of case would be a personal injury case. Because that falls under state law, a state court has subject matter jurisdiction to hear the case. Also, state substantive and state procedural law would be applied to this matter. Same facts as the first example. However, let's assume that the car accident occurred as a result of a defect in the manufacturing of the Chevrolet Camaro. Danny is from Las Vegas, Nevada. Peter is from California, and he sues Danny and Mary Barra as the CEO of General Motors. General Motors is a company organized and incorporated in the state of Delaware. Which court has jurisdiction over this case? Here, it would be the state court because the amount in controversy has not been satisfied. After we figure out who has subject matter jurisdiction over the case, and then we figure out which law we're going to apply, either state or federal law, as it relates to substantive and procedural law, then we might have to figure out which substantive law we're going to apply from which state. These are sample conflict of law principles. Conflict of law refers to procedural law and it deals with the choice of law rules when a legal action implicates the substantive law of more than one jurisdiction. This chart shows us how stare decisis works in a dual court system. Stare decisis is the legal principle of determining points in a litigation according to precedent. When an issue has been previously brought to the court and a ruling has already been issued, then a court engages in vertical stare decisis when it applies precedent or rulings from a higher court. Horizontal stare decisis refers to a court adhering to its own precedent. In addition to subject matter jurisdiction, a court must also have personal jurisdiction over the parties to render an enforceable judgment that affects the parties' rights and duties. Personal jurisdiction is the power to bind the parties involved in the dispute. A court has PJ over a plaintiff when the plaintiff submits to the court's power by filing a complaint with the court. To have personal jurisdiction over the defendant, the plaintiff must establish the constitutionally imposed requirements to a court's satisfaction. A court may obtain personal jurisdiction over a defendant via either in personam PJ, in rem PJ, or quasi in rem PJ. IPPJ is jurisdiction based on claims against a person and is limited by statute and the Constitution. As it relates to statutory limitations, a court will not be able to exercise personal jurisdiction over a defendant unless a statute exists in the form state that explicitly authorizes the court to exercise PJ over that defendant. A court satisfies the statutory requirement by establishing one of the following. First, he can establish physical presence. 2, domicile. 3, consent. 4, waiver, or 5, by reasonable notification to a party outside the state in those instances where a long-arm statute applies. Consent means that the defendant expressly or implicitly consented to the form as their choice of law. Express consent, for example, would be a choice of law clause in a contract. Implied consent would be a non-resident motorist statute. Waiver, on the other hand, is when the defendant acts in a way that is inconsistent with his argument that the state does not have personal jurisdiction over him. It is important to note that long-arm statutes cannot offend traditional notions of fair play and substantial justice. IPPJ also has a constitutional limitation. Pursuant to the Due Process Clause of the 14th Amendment, no person shall be deprived of life, liberty, or property without due process of law. The Supreme Court in International Shoe v. Washington has established the minimum contacts test. In order for a court to exercise personal jurisdiction over a non-resident defendant in a manner consistent with the Due Process Clause, the defendant must have minimum contacts with the form state such that it would be fair to force the defendant to defend a lawsuit there. Exercising personal jurisdiction cannot offend traditional notions of fair play and substantial justice. Minimum contacts means that the defendant must purposely avail themselves to personal jurisdiction in that state, which depends on the nature and the quality of the activity. Fair play and substantial justice means that the claim must be related to the contact in order for it to be fair for justice. The concept of minimum contacts can be discussed with respect to a spectrum. So if the defendant does not have any contact with the state, then the state cannot exercise IPPJ over the defendant. If the defendant's contacts with the state are isolated and specific, and if the claim arises from the defendant's contacts with the state, then the state is said to have specific in personam personal jurisdiction over the defendant. However, if the defendant's contacts are continuous and systematic, then the state has general IPPJ over the defendant. It is important to note that mere purchases in a form state without more is not sufficient to sustain a finding of minimum contacts. On the other hand, in rem jurisdiction is jurisdiction based on claims against property. Courts have jurisdiction to adjudicate claims to property situated within their state if the plaintiff gives those persons who have an interest in the property reasonable notice and an opportunity to be heard. Lastly, we have quasi-interim jurisdiction. That is the jurisdiction over property that is not based on claims against the property itself. This is jurisdiction over property, not the person. It is invoked by seizing the defendant's property within the state to obtain payment of a claim against the defendant that is unrelated to the property that's being seized. Civil procedure is the body of law that sets out the rules and standards that courts follow when adjudicating civil lawsuits. Pleadings serve the function of giving notice to the opposing parties. In the complaint, each claim for relief should contain, first, a short statement of the grounds for the court's jurisdiction, second, a short statement of the claim showing that the pleader is entitled to relief, and third, a demand for judgment for relief, which may be in the alternative. The summons is a court document stating the name of the plaintiff and their attorney and directs the defendant to respond to the complaint within a fixed amount of time. It gives the defendant notice and informs them that a lawsuit has been commenced against them. When you couple the complaint with the summons and you serve that to the defendant, we call that service of process. There are multiple ways of giving service of process to the defendant. It could be personal service, leaving a copy at the defendant's residence, or certified mail. Next, the defendant must respond to the complaint. If he doesn't respond, he will get a default judgment. He can make a number of pre-trial motions before even answering the complaint. He can file them and raise any or all of the following defenses. He can claim a lack of subject matter jurisdiction, lack of personal jurisdiction, improper venue, insufficient process, insufficient service of process, failure to state a claim upon which relief can be granted, or failure to join a party needed for a just adjudication. When the defendant answers the complaint, it must contain a specific denial or admission of each averment of the complaint, or a general denial with specific admissions to certain averments. Where the defendant is without knowledge or information sufficient to form a belief, then a statement to that effect constitutes a denial. A failure to deny constitutes an admission. The answer must also state any affirmative defenses the defendant may have, such as the statute of limitations, statute of frauds, res judicata, or otherwise. After the pleadings, we have pretrial procedure, which is the process of requiring the parties to disclose what evidence is available to them to prove the disputed facts. It is designed to encourage settlement of cases or to make the trial more efficient. After that, we have the trial, which determines the facts and the outcome of the case. If there is a federal civil case at common law where the amount in controversy is greater than $20, then the United States Constitution guarantees a right to a jury trial. Jury trials are not usually available in equity. Parties may waive trial by jury rights. On appeal, courts determine whether the trial court committed prejudicial error. Prejudicial error is a mistake about the law or court procedures that causes substantial harm to the appellant. This includes things like mistakes made by the judge about the law, incorrect jury instructions given to the jury, or errors or conduct of the lawyers or the jury. There are 3 standards of review. Abuse of discretion is used if appealing a decision that involved the trial court's use of discretion. Any decision that involves the judge using their discretion would be applicable here. Discretion means things like whether or not to admit certain evidence in the trial. Abuse happens when a trial court judge makes a ruling that is arbitrary or absurd. This really doesn't happen often. Then we have the substantial evidence standard of review. That one is used if appealing because the appellant thinks that the decision of the trial court is not supported by substantial evidence. Here, the appellate court's function is not to decide whether they would have reached the same factual conclusions as the judge or jury. They are only reviewing the record to be sure that there is some substantial evidence that reasonably supports the trial court's decision. The finder of fact is in a better position to decide what actually happened. De novo means from the beginning. Under this standard of review, the appellate court does not defer to the decisions of the trial court. Instead, it looks at the issue as if the trial court had never ruled on it. De novo review is usually limited to issues involving questions of law. Following any applicable appeals, we have the enforcement. There, the plaintiff with an unpaid judgment may resort to a writ of execution to have the sheriff seize the property of the defendant and to garnish and collect any money owed to the defendant by a third party that would ultimately go to the plaintiff as well. If you have any questions on Chapter 3, please feel free to send me a message, or you can always talk to me after class.